Okay, this class is about EU citizenship from a legal point of view, and I'd like to address three questions in this class. The first question is, who is the EU citizen and how is the European individual constructed? Now, in the construction of the European individual, I think what is important to point out is, first of all, the legislative instruments that have been adopted throughout these recent decades, starting from the Treaty of Maastricht signed on the 7th of February 1992, which introduced the legal concept of citizenship and which marked, therefore, a first move away from a purely economic union towards a more political union. And then, of course, the last but not least Treaty of Lisbon, signed on the 13th December 2007, which, although changed quite little in provisions of the Treaty of the EU citizenship, emphasised two particular elements. First of all, the principle of non-discrimination on grounds of nationality, and second, the element of representative and participatory democracy, for example, by introducing the possibility of a citizen initiative, which we'll talk about later. Another instrument which is important to mention is also the Citizenship Directive 2004/38, dating back to 2004, which merged into a single legislative instrument all the previously existing instruments, and which has basically based on a division of different of EU citizens into different categories, starting from a worker and moving on to the self-employed person, then student, family member, the retired person, and so on. What the Citizenship Directive does is actually to list a set of rights for EU citizens. And the first set of rights is the rights of free movement, meaning the right to freely move across the territory of the member states, to reside there, and to generally live in another country simply by showing a valid identity document or a passport. And this right is accorded not only to so-called EU citizens, but also to the family members, even when their family members are not actually belonging to a third country, so to a non-EU country. Now, there's a distinction as well between stays below or above 3 months. For stays of less than 3 months, in this case, as I said, the only requirement for EU citizens and their family members is to possess a valid ID document or passport, although, of course, the country of residence can request additional requirements, so can actually demand registration of the citizen. For stays of longer than 3 months, then in this case, EU citizens fall within specific categories, which I already mentioned before. So in order for the person to be able to exercise free movement rights, he or she has to be either a worker or self-employed person, or must have sufficient resources for him or herself or the family members in order to ensure that he or she does not become a burden for the state in which he or she resides. And in addition to this, he or she must have a comprehensive health insurance. Where, in addition to these other categories which benefit from citizenship rights are those who study, including vocational training, and in addition to this have sufficient resources and a comprehensive health insurance. And also, in addition to this, all those who are family members, as I said already, who accompany or join a EU citizen. Of course, under certain conditions, in case of death of a EU citizen, or in case of termination of partnership, annulment of marriage, divorce, and other similar situations, the family members still retain the right to reside in a country of residence. Right? In addition to these free movement rights, EU citizens also have a right of permanent residence. This permanent residence is accorded after a period of 5 years of residence in a country, in a host country. Of course, although of course this residence has to be uninterrupted. In this sense, then, EU citizens can only be expelled from the host country for serious reasons, which have to be reasons of public policy, public health, or public security. These measures that therefore are directed to deporting or removing EU citizens can only be applied when they comply with the principle of proportionality, and they can only be based on the personal conduct of the EU citizen when this personal conduct amounts to a sufficiently serious, genuine and present threat to the fundamental interests of the society. And in this sense, previous criminal convictions do not count alone, so do not automatically justify expulsion of the EU citizen. So, one first conclusion that we can draw from the analysis of free movement and citizenship rights is that, certainly, as the Court of Justice of the European Union has actually ruled, EU citizenship is destined to be the fundamental status of nationals and member states. But the question is then whether the status of EU citizenship can be considered the primary legal status of nationals and member states, or whether instead it's more like a residual category, which is in a sense supplementary to those legal categories that we mentioned before. So workers, self-employed, family members, retired people, students, and so on. In any case, Article 20 of the Treaty on the Functioning of the European Union, which is one of the treaties that compose the so-called Treaty of Lisbon, says that EU citizenship shall be additional to and not replace the citizenship of each of the member states, which means, of course, that EU citizenship is contingent upon the possession of the citizenship of the member state of nationality. In a sense, therefore, EU citizenship does not amount to a different status. It is more like an overlapping concept. But we will come back to this question later. One second question I would like to address now is what are the political rights of the EU citizen? Now, although, of course, these rights do not have a particularly broad scope, they are still important for our purpose, at least symbolically, and if not more. The first set of rights, in this sense, is so-called rights to alien suffrage, which means passive and active electoral rights of EU citizens, in the sense that EU citizens have the right to vote and to stand as candidates in elections, both European Parliament elections and municipal elections, in the country of residence. Not, of course, the national elections, which is already, of course, an important step towards building up of so-called EU citizenship. And the second set of rights, then the right to protection of diplomatic and consular authorities of in a third country, diplomatic and consular authorities belonging to any member state, whenever in that third country the member state of nationality is not represented. The third set of rights then is also the so-called Citizens' Initiative, as I mentioned at the beginning of this class, which means that 1 million EU citizens have the right to invite the European Commission to bring forward certain legislative initiatives, although, of course, the European Commission is not obliged to promote and move forward these proposals. And finally, EU citizens also have the right to petition the European Parliament, to apply to the European Ombudsman, and to address the European institutions in any of the official languages of the European Union, which are currently 24, and as well to obtain a reply in that same language. Now I'd like to go to the third question that I'd like to in particular address, which is what is the relevance of the Court of Justice of the European Union for the configuration of the EU citizen as a member of a transnational polity? Now, what I'd like to first preliminarily point out is that the Court of Justice of the European Union is not to be equal to the European Court of Human Rights. The European Court of Human Rights belongs to a different organisation, the Council of Europe, and deals with human rights. Although, of course, it has in the past addressed issues related to deportation or dual nationality, it is not competent in the context of EU law. Whenever issues relating to the application and interpretation of EU law provisions come up, then the Court of Justice of the European Union is competent. Of course, the Court of Justice has in the past repeatedly referred to rulings by the European Court of Human Rights. But of course, that is quite a different matter. Now, the Court of Justice in particular, as I say, has played a pivotal role in shaping the status of citizenship of the European Union. And I would like to in particular focus on some of the case law, because much of its case law, of course, has been basically incorporated into the treaties of the European Union. Now, one first important case is the so-called Boundbus case. Now, in this case, Mr. Boundbus, a German national, lived in the UK with his family members, in particular his wife, who was a Colombian national, and his children. Now, at one point, he had to leave the UK to go to Asia, Africa. His family members remained in the UK and continued living there, and also travelled to Germany for health reasons, so using the services there, in particular comprehensive health insurance that they had in Germany. Now the question is, do family members of Mr. Boundbus retain free movement and citizenship rights whilst being separated, so not actually accompanying or joining him? And the Court of Justice of the European Union has, in contrast to its previous case law on the matter, ruled that in this particular case, although family members are neither employed nor self-employed, they may also fall within the category of EU citizens. First of all, because the principle of proportionality applies in this case. And secondly, because in any case, the right to EU citizenship should be considered as such. So this means that the right to EU citizenship, we can conclude, the right to EU citizenship is an autonomous and directly effective right, which operates regardless of whether the person falls within one of the specific legal categories mentioned before, in the sense that it emerges as such as an independent set of benefits that are accorded to EU citizens. This approach, the Boundbus approach, has been followed by the Court of Justice also in other cases, starting from the Zoon Chen case. In this case in particular, Ms. Chen was a Chinese national who moved to the UK and subsequently also moved to Northern Ireland and gave birth to her child there. As a result of this, her child acquired Irish nationality because of Irish law, so because of being born in Northern Ireland. Now, the point is that they both, mother and child, applied for a long-term residence permit, but the UK Secretary of State denied this permit on the ground that although the child was fully dependent on her mother, and although anyway both child and mother had sufficient resources to not to be a burden on the state of residence, and also had a health insurance, despite this, the child had not exercised her free movement rights, because in order to trigger application of EU law, it is necessary for the EU citizen to actually move from one country to another. And no doubt, of course, Miss Chen's child was a EU citizen by virtue of being born on the territory of a EU country. Now, the Court of Justice actually ruled in this case that, first of all, in this case particularly, EU law applied, because although the child had never moved from the UK, had always lived in the UK, she actually had acquired the nationality of a different state, in this case Ireland, and by virtue of acquiring Irish nationality, she therefore was entitled to citizenship rights. And secondly, although the mother could not be considered a dependent relative, actually the other way around was true, in this case she still enjoyed a so-called derivative right of residence. So she had a right to reside in UK as a consequence of being the mother of a EU citizen. And in this sense, therefore, refusing, the Court of Justice argued that refusing a right to residence to the mother would amount or would deprive the child's right to residence any useful effect. So it would basically leave it as an empty shell. this is basically, therefore, a consideration of justice, which we find also in another case dealt with by the Court of Justice, so-called Ruiz Zambrano case. This case concerned a couple of Colombian people who had moved to Belgium and resided there and applied for asylum on a short-term visa. And this application was rejected repeatedly by the competent Belgian authorities because of the situation in which they were. But in this particular case, although the Belgian authorities refused the asylum application, they still argued that the couple could not be sent back to Colombia because of the situation of civil war there. In the meantime, anyway, the couple had also 2 children. Mr. Zambrano also worked in Belgium and actually had to, at one point, had to be fired because the authorities found out that he did not have a work permit. The couple then kept applying for residence documents, and one tribunal decided at this point to refer this particular case to the Court of Justice of the European Union. And the Court of Justice of the European Union ruled that although in this particular case a citizenship directive, so Directive 2004/38, did not apply because that directive only applied, as I said, to EU citizens who move and reside in another member state. Still, the application of EU law had to be argued because of the children of the Zambrano family. The children of a couple of Colombian nationals, indeed, had been born on Belgian territory, and by virtue of acquiring Belgian nationality by birth, of course, they were also EU citizens. Therefore, in this case, rejecting the application, the residence permits application by the Colombian couple, would amount to depriving EU citizens, so children in this case, of the genuine enjoyment of the substance of EU citizenship rights. Therefore, it had to be the case that even in this case, EU citizens are not actually moved from one country to another because of consideration of justice. The rights that they enjoyed had to be referred also to their parents. Now, this consideration of justice we find also in other cases, like, for example, the McCarthy case. But in other cases, the Court of Justice actually has denied a similar effort, has denied that in the absence of actual movement from one country to another, there could be derivative rights of residence. But in those cases, the reason was that those cases involved actually adult people, so adult relatives who were not dependent on another person. So in that case, of course, it is believed that the Court of Justice reasons in terms of practical justice, in the sense that only when the person is actually vulnerable and dependent on another relative, only in that case would then the consideration of derivative rights of residence be taken into account. It is important also that, anyway, in other cases, such as this McCarthy case, the Court of Justice added that the fact that the applicant has never exercised his or her rights of freedom of movement is insufficient in itself to conclude that EU law would not apply, which, of course, leaves it open for the court to decide in a flexible way in similar cases. So we can see that actually the case law of the Court of Justice is in a constant move. It's actually constantly progressing, and there are several nuances that we can see, and that we can also actually analyze the reasoning of the court depending on different practical cases. We can see that the Court of Justice actually applies, interprets and applies the scope of EU citizenship, having a look not simply at EU law but also at other considerations. So, thank you very much.